The
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your relatively bi-weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by Evan Bernick of IJ's Center for Judicial Engagement and IJ litigator Paul Sherman, who's excited to be here today.
I'm excited to be here today.
If you enjoyed the Short Circuit podcast, you may also enjoy the Short Circuit email newsletter. To subscribe, visit ij.org/shortcircuit. This week on the show, indefinite detention, the SCC's unconstitutional judges, qualified immunity for social workers, and a vexing property rights case. Evan, kick us off.
I'd like to point out that I am also excited to be here today. The first case comes out of the Eighth Circuit and involves a constitutional challenge to a system of civil commitment in the state of Minnesota. This statute has been in place since 1994, and it provides that a county prosecutor can make a motion with a local district court to provide for the indefinite civil commitment of somebody who is deemed to be sexually dangerous after they have committed a sex offense and they've finished serving out their time. A number of individuals who have been detained there since, for varying periods of time. I think only one individual has ever actually been released after being committed pursuant to this. And they argue that this violates their constitutional rights, that the standard for getting in is a lot more lax than the standard for getting out. So it's difficult to actually get out. There are no regular proceedings to determine whether you are still sexually dangerous. And the question in this case is whether that constitutional challenge can go forward.
Yeah, the facts are pretty remarkable. The record actually shows that there are 714. So this program's been around for like almost a quarter century. 714 people have been put into the program. Nobody has been fully released from the program, and only 3 people have been provisionally released, which means that they're subject to continued monitoring. So that they can check you in, but you can't check out.
Right. So the theory is that this is not punishment. This is just designed to ensure that they are no longer dangerous and that they won't threaten the community in any way. But obviously, there has to be a limit to that principle. Otherwise, you're essentially imposing a life sentence upon people. And what the court does in this case is they consider whether these individuals have a liberty interest that's even implicated in the first place. And in a remarkable, I think, example of judicial abdication, the court determines that, well, in assessing the liberty interest at stake, we must recognize that while liberty is not a general license to do whatever you want, so essentially we can apply what is the default level of judicial scrutiny in this case, which is the rational basis test, rather than a heightened standard of scrutiny that we would apply if a so-called fundamental right was implicated. Now, even though the freedom of movement or the freedom of locomotion lies at the core of due process of law and its guarantee of liberty, the court concludes that the rational basis test is the proper way to go because the court hasn't expressly addressed this in the context of civil commitments.
Yeah, so this highlights one of the sort of the classic games that federal judges are able to play under our current system of judicial review, where whether you get strict scrutiny or real meaningful judicial review, or whether you get rational basis scrutiny, which is not a particularly meaningful level of judicial review, turns on the specificity with which the court defines your legal interest. So if you look at it at a higher level of generality, people have a right to be free from restraint and to move around freely, but you can always lower that interest to a degree of specificity where, of course, there's not a strong historical precedent. There is no strong historical precedent for the idea that people who have been convicted of sex offenses have an unlimited right to be free in their locomotion.
Right, and the difficulty that you get into and the reason why you need to engage in that inquiry in the first place is because in identifying fundamental rights, the Supreme Court has set forth a two-pronged test. The right has to be both deeply rooted in the nation's history and tradition, but it also needs to be narrowly specified, particularly defined. So in order to establish that freedom of locomotion is deeply rooted in the nation's history and tradition, that's not particularly difficult. That's a very easy thing to do. to. I mean, you can go all the way to Blackstone for that, prior to the founding. But if you want to define it in a way that's sufficiently precise for the court to accord it fundamental right status, then you need to get a lot more specific. And the more specific you get, in this particular case, the less likely it is that your right is going to be recognized as deeply rooted in the nation's history and tradition. And the result is the fundamental right doesn't get acknowledged, and we get rational basis review, which is tantamount to no review at all. Utter judicial abdication.
Yeah, and in this case, that happens to be outcome determinative. So at the trial court, the court said that this freedom from restraint is a fundamental right. It's deeply rooted in our nation's history and tradition. So the judge applied strict scrutiny, and he struck down the system of involuntary civil commitment, and he ordered that they start having hearings for these people to determine whether they were still sexually dangerous or whether they had to be released. And the Court of Appeals reverses that with very little analysis, and essentially their reasoning comes down to, obviously it's rational to restrain people from society if we have some reason to believe they're sexually dangerous. Unfortunately, I think this is also a case where you've got a class of plaintiffs who are very unpopular, sex offenders, not just sex offenders, but convicted sex offenders, people who have served time in jail. But as a result, I think the court gets some very fundamental constitutional analysis wrong.
Yeah, and I think another thing that happened in this case is you can see the court running through an analysis which presupposes its belief that this thing is probably justified in terms of defining the right in the first instance. So what the court would ideally do is to recognize, yes, we have a fundamental right, and then turn around and ask the government to justify a burden on that right with particularized evidence by showing that these procedures are necessary in order to protect its vital interests. Everybody acknowledges that protecting people from sexually dangerous offenders is a vital interest. But you don't take that analysis, that justification, and price it into the right in the first instance. You acknowledge the rights, and then you turn around and compel the government to demonstrate that its burden on that right is reasonable.
Yeah, otherwise you're just bootstrapping.
Absolutely.
Okay, let's move on to the next case, which comes out of the Ninth Circuit. Paul?
Yes, so this is an interesting case, not because it's particularly legally groundbreaking. In fact, the outcome seems like total common sense, but it's an amazing illustration of an issue that's kind of a recurrent problem for people who sue the government for violation of their constitutional rights, and that's called qualified immunity. So when you think that the government has violated your constitutional rights, when a state official has, you sue them under this federal statute called Section 1983. But there's an exception under Section 1983 that's been invented by courts called qualified immunity. And your case won't be allowed to go forward if the constitutional right you're asserting was not clearly established at the time the violation happened. And the idea behind this is government officials may be acting reasonably but mistakenly, and they end up violating your constitutional rights, and it would be unfair to hold them personally accountable for this. There's a lot of criticisms you could make to this point and to the way we've set up the qualified immunity system, but that's the existing rule. This case, Hardwick versus County of Orange, involves some social care workers who are alleged to have affirmatively lied, to have hidden evidence, and basically have suborned perjury, resulting in a woman losing custody of her kids for a period of years. So they've filed a Section 1983 lawsuit against these social care workers, saying this obviously violated our constitutional rights. And the attorneys representing the social workers had the gall to argue that it was not clearly established that perjuring yourself or destroying evidence are unconstitutional. The court makes pretty short work of this and actually has some interesting turns of phrase along the way.
Yeah, there is a shame on you tone to this opinion, and it is very well deserved. If you look at the transcripts of the interactions between the attorneys for these officials and the Ninth Circuit panel, you really get a flavor of it. I mean, these attorneys are actually arguing on behalf of these people who are being sued now for millions of dollars as a consequence of this woman being separated from her two daughters for an extended period of time, that they weren't on notice that you can't lie in court and you can't perjure yourself in order to separate a woman from her children. It's just, I mean, you laugh that you might not cry. It is so outrageous. And what the Ninth Circuit does is it comes down hard and makes absolutely plain that nobody whose IQ is higher than the temperature of a room in Alaska could possibly believe that this was a legitimate thing for you to do. So
yeah,
I mean,
and that's not an Evan Bernick original. That's a Judge Stephen Trott of the Ninth Circuit original.
Yeah, I mean, it's remarkable, it's outrageous, and the Ninth Circuit came down hard appropriately. I mean, this has been going on for something like 16 years now. The original actions that gave rise to the suit in the first place happened in 2000. So with, taxpayer money, they are hiring attorneys to argue in court that government officials weren't on notice, that perjuring people committing perjury to separate children from their families was something that was unconstitutional.
Another good point that the court makes here is that so one of the things that goes into determining whether a right is clearly established is whether there's case law establishing that right. But what the court points out is that for the easiest cases, that's never going to happen. There's never been a case, for example, where the foster care system has been taking kids and selling them into slavery. But that doesn't mean that if the foster care system started selling kids into slavery, they could go into court and say, oh, we didn't know that there was a constitutional problem with our doing that.
Right. And relevant to the instant case, you have state and federal laws on point that specifically forbid you from lying in court and fabricating documents. And the notion that you have a fundamental interest to raise and guide the upbringing of your children is something that's been recognized by the Supreme Court for, over a century now. So the idea that they weren't on notice is just absolutely absurd.
I'll just add for our listeners who might have come across the podcast through reading on the Volokh conspiracy, Volokh conspirator Will Bode recently blogged about a new article he has that questions whether qualified immunity is justified. And he takes on kind of the three historical arguments for qualified immunity and finds them all to be wanting. So I would commend that to all of your attention.
We will post a link. But now on to the next case. Evan?
So this case comes out of the 10th Circuit, and it arises from an SEC enforcement action, a securities fraud action that was brought against one David Bandemir in 2012. Bandemir was found liable for securities fraud violations and turned around and constitutionally challenged the very existence of the authority that determined that he was liable, namely the SEC administrative law judge who determined that he had violated securities laws.
So just so that people know, there's this tremendous body of agency law and, expansive administrative agencies. And when they think that you have violated the law, it's not necessarily the case that a prosecutor drags you before a federal judge. They'll drag you before what's called an administrative law judge who works for the agency.
Right. So, and you get a trial-like hearing. The court is careful to say that, as opposed to a distinct trial with a jury and with the traditional rules of evidence. You don't get that in an administrative proceeding, but we're getting beside the point. The point here is that this is a constitutional challenge that's predicated on the idea that this individual, this administrative law judge, was not appointed in conformance with constitutional procedures for appointments. The Constitution provides specific procedures that inferior officers, as they're referred to, people who wield significant government authority under the United States, must go through. They either must go through a Senate confirmation process, or Congress can vest the authority for selecting these officers in essentially three sources, none of which are applicable here. This guy obviously wasn't appointed in conformance with that process. If he is an inferior officer, he didn't have the authority to be in the position that he was and determine liability in the way that he did. So is he an inferior officer? That's the question for the court.
And like big implications turn on this, right? Because the SEC has 5 administrative law judges. They issue a lot of decisions. If they are all inferior officers who have been improperly appointed, that calls lots of decisions and future decisions into question.
Right, but then again, you do have the Constitution. You have a very specific process that's set forth. If this guy is an inferior officer, he's got to be appointed through procedures that are other than the ones that he was actually appointed through.
So given that magnitude, this is obviously a candidate for further review?
Absolutely.
Okay, let's move on to the final case, Paul.
So this is another case that kind of highlights, it's not a blockbuster case. It's not even one that was subject to full text publication. But it sort of highlights, I think, just the classic grassroots tyranny of small town city councils and zoning boards and how difficult it can be to challenge that sort of thing, even when their behavior is at its most brazen. So the case is out of the Sixth Circuit. It's called Lilly Investments v. City of Rochester. And it involves this guy who wanted to open up a dental clinic in Rochester, Michigan. He got into a dispute with the city council. He wanted to do it in this historic building. And his preference would have been to knock down the building and just build from scratch. Their preference would have been that nothing about the building changed. And they ended up with this compromise, which was somewhere in the middle, that was going to retain aspects of the building, but still allow him to go forward with his plan. And at some point along the way, the city decides that he's not sufficiently protecting this building, and they issue a stop work order. And then a little bit later, their expert says, okay, now he's brought everything into compliance. He's doing what he's supposed to do. And at that point, the city says, okay, we will rescind the stop work order if you pay us $40,000.
It's actually even worse than that. They offered to consider rescinding the order if he paid the $40,000.
Yeah. So, I mean, basically just they've got this guy over a barrel, and they're trying to squeeze money out of him.
Right. There's really no other way to describe this other than extortion. It's probably unconstitutional given that the government can't actually force you to relinquish, in this case, your constitutional claims as a condition of exercising a constitutional right. In the back and forth, I would just suggest that you read the opinion to recognize what happened here. Essentially, they were never happy with this project. They took advantage of the leverage they had over him to try to push the project in a direction that they wanted, and they wanted ultimately to prevent this from even getting before the courts in the first place, which is unfortunately something that the Supreme Court has made it possible for planning commissions like this to do by virtue of creating procedural hurdles to regulatory takings claims.
Yeah, so there's tons of procedural gambits that take place in this case. But so the first thing that happens is eventually these negotiations totally break down, and the property developer just says, I'm suing you guys. And he files an action in Michigan state court alleging what's called a regulatory taking. So a regular taking is when the government, takes your land and bulldozes it and builds something new there. A regulatory taking is when the government enacts some kind of regulation that destroys the value of your land. And what you can do then in some circumstances is go into court and say, look, I had this property that was worth X. Now it's worth 0. You need to compensate me for that destruction of the value of my property. It is a federal constitutional claim. So what the town did is they removed the case to federal court. And then when they were in federal court, they tried to get the case dismissed.
Right, because the Supreme Court in a case called Williamson County has actually held that there are two prerequisites that you have to go through before you bring a regulatory takings claim. You have to have a final decision. That was a point of issue. The commission said, well, we never reached a final decision. And the second is that you need to exhaust your state law remedies, or you have to go through state court first. And the commission tried to avoid that in this case by removing the action that was initially brought in state court to federal court and then saying, hey, Williamson County, you obviously haven't exhausted your state level claims, or you haven't exhausted your state court claims, essentially making it impossible for them to go forward with that constitutional claim.
And the district court bought that.
Yeah, I mean, this is a problem that people face all the time in these cases. But luckily, the Court of Appeals didn't buy it, and the Court of Appeals rejected both arguments. First, it said that what really matters in terms of exhaustion is, would it be futile for you to go forward? Like, have you guys reached an impasse that you're not going to get through? Because otherwise, the state could always avoid moving forward with these cases by just putting by stringing along negotiations or just making things too outrageous.
I mean, it's not final yet. It's kind of final. You might have to do a few more things, but
yeah. But so the court says it's final enough for us. And then the court, I think quite appropriately, says we're not going to let you do this game playing where you consent to putting this case in federal court and then say, oh, we're upset that we're not in state court. So the case is allowed to go forward. Who knows whether Louis Lenore is going to win this case or not, but at least he's going to get his day in court. And he's going to get his day in court because the court here was engaged.
Okay, that concludes the show. Thanks for listening, and we'll be back later this month. And so until next time, this is John Ross from the Institute for Justice, blandishing you to get engaged.